Colleagues, we will get started. Call this meeting to order. Welcome to meeting number 71 of the House of Commons Standing Committee on Government Operations and Estimates, also known as the mighty OGGO, the only committee that matters. Pursuant to the order of reference adopted by the House on Wednesday, February 15th, 2023, the committee is meeting for clause-by-clause consideration of Bill C-290, an act to amend the Public Servants Disclosure Act. We have with us our back from Treasury Board, Ms. LaRoche and Ms. Stevens. I ask if you have questions for them, just direct them directly to them, please. And of course, we welcome our legislative clerks. Just really quickly, colleagues, July 19th, it appears we'll have the departments back in for the McKinsey documents. Like before, I'm just seeking our unanimous consent that we limit their speaking times to 2.5 minutes for the introductions. The 19th.
You said July.
Sorry, June 19th.
I was ready to crumple something.
Oh, no. Well, the meeting will still be going on. There'll be a filibuster. June 19th, is that fine, colleagues? June 19th, we'll have the departments back in for the McKinsey documents, seeing as there's 8 of them. We're just looking for unanimous consent, so we'll provide them with 2.5 minutes each instead of the 5, so they'll actually have time to meet with them. Wonderful. Ms. Vignola, you have your hand up.
So if I understand well, June 19th will not be used for C-290, right? So June 19th will not be used for C-290. Okay. So I'm sure we are, je suis convaincu qu'on est tous de très bonne volonté.
I'm convinced that we all are of goodwill and that we want to pass Bill C-290 as quickly as possible, but nonetheless, I tabled the motion that I sent to the clerk. I'm going to read it in both official languages.
De 30 jours de séance pour étudier le projet de loi C-290, loi modifiant la loi sur la protection des fonctionnaires divulgateurs d'actes répréhensibles, renvoyé au comité le mercredi 15 février 2022.
Sorry, Ms. Vignola, sorry, we have to wait.
The interpreter does not have a copy of the motion, and she said she would read it in both official languages. According to the interpreter does not have a copy of this motion, and Ms. Vignola said she would read it in both languages.
10. Loi modifiant la loi sur la protection des fonctionnaires divulgateurs d'actes répréhensibles, renvoyée au comité le mercredi 15 février 2022, afin d'accorder au projet de loi l'attention qu'il mérite et que la Chambre présente et que la présidence présente cette demande à la Chambre. En anglais.
In English now.
To Standing Order 97.1, the committee requests an extension of 30 sitting days to consider Bill C-290, an act to amend the Public Servants Disclosure Protection Act, referred to the committee on Wednesday, February 15, 2023, to give the bill the consideration it requires, and that the chair present this request to the House. Juste pour être sûr.
Thanks. Mr. Fergus, you wanted to chime in on this?
Oui, Monsieur le Président, nous sommes favorables.
Yes, we are agreeable with this demand. Let's hope that it's not necessary and that will end all our work today, but I believe that it's appropriate.
Mr. Fergus, do we have consent for that, colleagues? Basically, it just gives us an opportunity if we're not able to finish it this month. Wonderful. So be it. Thanks, everyone. We are going to get right into the clause by clause. We're resuming consideration of Amendment G7, which has already been moved by Mr. Fergus in Clause 12. G7 is on page 26 of the package. Shall G7 carry? Wonderful.
No.
Oh, sorry. Mr. Johns, go ahead.
So it cancels. So it limits the options available to the whistleblower. It provides only one recourse method at the time. It cancels C290's repeal of 19.3 Section 2 and 19.3 Section 3, which prevent the commissioner from dealing with a complaint if any other measure has already been taken. Example, the collective agreement. And we heard from the experts that circumstances may require that more than one method of recourse be taken, and that certain methods of recourse often take years. So it isn't reasonable to require the whistleblower to wait years before beginning another method.
Mr. Fergus?
Respectfully disagree with my colleague, Mr. Johns, and clearly because that's the reason why I want to bring this forward. This amendment, and actually there are going to be a number of them, are going to prevent any overlaps with other recourse mechanisms for reprisal. Because if we don't do that, then what we're going to have is that we're going to have multiple processes being conducted on the same issues by different administrative bodies with differing mandates, objectives, and that would be a waste of resources, one, and B, I think the greatest concern is that it could come out with inconsistent determinations, which would be offering different remedies. So so I think that's the principal reason why there is this change.
Ms. Vignola?
Très rapidement.
Very quickly, when we used union resources, grievances can take years, and then there's a need to have more than one resource that can be used. This being said, I have the impression that we won't agree on the finality of G7 and seeing if we are going to accept it or not, and so I'd call the vote on G7.
Yes, let's vote on it.
On G7, Mr. Baines.
Yes.
Mr. Fergus.
Oui.
Mr. Jawari.
Support.
Mr. Kuzmirchik.
Support.
Ms. Thompson.
Support.
Ms. Block. Mr. Shipley.
Yes.
Ms. Kuzi.
In favor.
Madame Vignola.
Non.
Mr. Johns.
No.
Eight yeas, 2 nays.
Colleagues. So we're on to Clause 12. Shall Clause 12 carry? As amended. As amended. On division, colleagues. Clause 12. Carried as amended on division. Thank you. We have new clause 12.1, which is G. It's Amendment G71, page 26.1 of the package. Mr. Fergus, are you addressing that?
Yes, thank you. This will, the sponsor had raised concerns about the 2017 Terrien case where a complainant was refused by the commissioner, was ultimately left without means to address the matter. This is an option. This is a way of making sure that we address this matter, that complaints are referred to the correct course or recourse mechanism. So from practical speaking, from now on, if the complaints that come to the commissioner that are assessed and refused, then the commissioner must inform the whistleblower of the most appropriate mechanism for dealing with the complaint. This is to make sure not to leave anyone hanging without options.
Ms. Manola?
Une partie du dommage qui a été faite.
C'est bon. On n'a pas d'argument à ce propos-là.
We have no arguments.
LG 7-1, then carry. On division? Great. 12-1 is therefore carried. Clause 13, G8, which is page 27 of the package, and maybe we'll go to Mr. Fergus for this one.
Thank you, Mr. McCauley. Also, thank you for getting my name correct. That's a joke between us. The day's young. This goes back to a debate which we had earlier with agreement of all parties that we would replace the terms reasonable belief, or we'd replace good faith with the notion of grounds on the basis of reasonable belief. This is the international standard, and this is the one that we all agreed to earlier on in the day. And this is basically carrying through, implementing that in different parts of the bill.
Colleagues, so G8 carry. On division.
We can vote on that.
Okay. We will, Mr. Johns.
On G8, Mr. Baines.
Support.
Mr. Fergus.
En faveur.
Mr. Juari.
Support.
Mr. Kuzmierczak.
Support.
Ms. Thompson.
Support.
Mr. Shipley. Sorry, Ms. Block. My apologies.
In favor.
Mr. Shipley.
Yes.
Ms. Kuzi.
In favor.
Madame Vignola.
Non.
Mr. Johns.
No.
8 yeas, 2 nays.
G8 carries. Shall clause 13 carry as amended? On division? Wonderful. Colleagues, there's no amendments to clauses 14 to 16. If we have unanimous consent, we can batch them. Mr. Fergus?
Actually, Chair, thank you very much for that. We actually do have we have a number of changes that we'd like to make or suggest. It affects clauses 14, 15, 16, 18, 19, 20, and 23. And this is all related to the note which I had shared with all members of the committee regarding what we are trying to do here with all these clauses allow folks to if they take a case to the PSIC and they're refused, or this opens up the door to allowing them to go directly to the tribunal. Here's the situation: the commissioner has a lower threshold for accepting or approving cases. It doesn't stand to logic to then, if the place with the lower threshold, if it doesn't work there, to send it to a place at the same time where there's a higher threshold. If you go straight to the tribunal, then you'll, first of all, I don't think it will work out. But secondly, what will happen is that a lot of work is going to go to the tribunal. the tribunal then will be hearing a lot of the same cases. This will increase dramatically the number of work of the tribunal, and frankly, I think to be fair, I think it would actually lead to the speaker ruling that there is a royal recommendation implication on this. So I know this is a situation where we actually have a.
Can I interrupt? Do you have a copy of the amendment you're proposing for clause 14?
I'm looking just to negate these clauses. They're all related. So in a sense, if we accept one, you should accept them all. But it would actually probably lead to a big use of resources. Which would you like me to repeat the clauses?
So, well, which clauses are referring to, please? 14.
14. The changes that are being proposed by Mr. Johns for, I think it's Mr. Johns. I might be wrong who had proposed it, but it's 14, 15, 16, 18. Sorry, this is proposed by Mr. Garon. 19, 20, and 23.
Getting some. I'm going to allow our ledge clerk to wade in here about how we'll actually have to address these one by one. Go ahead.
Thank you, Mr. Chair. Mr. Fergus, just to confirm, you are referring to Clause 14, Clause 15, Clause 16, Clause 17, and Clause 18?
14, 15, 16, 18, 19, 20, and 23.
Thank you, Mr. Fergus. And just one last point of clarification. You mentioned that these are amendments that have been proposed. We currently don't have an amendment to Clause 14.
My apologies. I didn't mean amendment. I should have said negate.
Negate. Okay, so to negate Clause 14, for example, the procedure that we are asked to follow according to the rules is that an amendment to delete a clause is not admissible. It would be necessary to vote down the clause. So when the chair puts the question on a particular clause and one is in disagreement, then the correct process would be to negative it, so to vote down instead of amending to delete it.
Fair enough.
Thank
you for that information. I will abide by that rule.
Colleagues, are we prepared to vote? Yes. Yes, great. So, sorry, go ahead, Mr. Fergus.
Just because I might have confused my colleagues by what I'd suggested, I just want to make sure I'm going to let you know I'm going to come back to the same point over and over again, but I'll make it once so that we could save time. And that is, again, is that we are asking to vote down these clauses one by one. The reason why, again, is that a PSIC decision would already have a judicial review in the federal courts, and removing the screening role of the commissioner and going straight to a tribunal would, frankly, doesn't make much sense because it's using a higher legal standard as opposed to the lower legal standard of the commissioner. And B, if we allow this to stand, then what you're actually going to be doing is you're going to cause a surge in cases to the tribunal, which will cause a surge in costs to the tribunal, and it may need a royal recommendation.
Okay, we'll go to a vote. Shall Clause 14 carry?
Clarify. I'm sorry, it's not clear if the member is voting, we're having a vote to delete the clause or to negate the clause. Okay, it's just to be clear, it's to negate the clause. Yes. Okay, all right.
Well, we'll vote on it, yes.
Okay, and I'm sorry, are we doing all of the clauses he mentioned at one
Yeah, there's
one
14, 15, 16, 18, 19, 20, 23. And we
Okay.
will get to them individually one at a time.
When we get there. Okay. And I'm sorry, when was this when were these amendments put forward?
We sent you a note on
Okay,
the...
but when was the there wasn't. Okay, so we're just informed now that they want to delete these clauses? Negate these clauses, excuse me. That's the proper terminology. My apologies. I'm
Mr. Fergus, are you addressing that question?
Yeah.
Okay, go ahead, please.
So just to answer that question, there was an email which I believe was sent by regarding it was a brief on the tribunal that we'd sent from our officials, and on the back of that note, or on page 2 of that note, it talks about the clauses that would need to be negated.
Chuck.
Thank you, Mr. Chair. If I could just ask the officials to comment on how these changes in C290 would impact the work of the tribunal.
I think we've already moved to a vote on this. Mr. Kuzmierczak, maybe on the next one?
I just think that maybe it would provide us with a little bit of a foundation before we get to the vote.
Well, I think the next one, we have said we'll move to a vote on it. Madam Clerk, go ahead for the vote. Show 14, carried.
Monsieur le Président, je veux juste être sûr.
Mr. Chair, I just want to be sure. I'm trying to be sure that I really have understood this correctly. So we're voting to take out the clause or to keep it?
And this will be the vote. I assume some people will vote to negate, some will vote no, some will vote yes.
Merci.
Thank you.
Madam Clerk?
Wait, Mr. Chair, I'm sorry, I do apologize. I was clear until that last second. Can you just clarify for me, please, what this vote is? Because I think there's a bit of confusion.
We're voting on Clause 14,
Yes.
whether we'll carry.
Whether we'll carry. Okay, so
Yes.
voting yes will carry it, voting no will negate it.
Yes or negate.
Yes.
Sorry. A good point, Mr. Kuzmierczak.
On clause 14, Mr. Baines.
Negate.
Mr. Fergus.
No.
Mr. Juari. Mr. Kuzmierczak.
No.
Ms. Thompson.
No.
Ms. Block.
Yes.
Mr. Shipley.
Yes.
Ms. Kuzi.
Yes.
Madame Vignola.
Oui.
Mr. Johns.
Yes.
I have 5 yeas, 5 nays. Chair?
Thank you for making things difficult, but I have an easy answer here. Page 786 of the Big Green Book suggests the chair vote yes to carry, so I will vote yes on that.
So 6 yeas, 5 nays.
Shall Clause 15 carry? Mr. Kuzmierczak, do you want to
Sure.
wade
Yes,
in now?
I would
Sorry,
just
Mr. Fergus,
ask,
but
thank you, Mr. Chair. I would just ask the officials to just comment on the changes that C290 that we've been discussing here, what impacts it would have on the work of the tribunal.
Okay, I'm going to talk. Thank you first of all for your question, and I'll talk about it very broadly and ask Marianne to to supplement my my answer. So I think Mr. Fergus explained it well. So right now, when there is a reprisal, it's only the PSIC that can actually hear or receive those complaints. The PSIC will determine whether there is it needs or not to refer the matter to the tribunal based on reasonable grounds. The amendments that we're proposing now would mean, depending on which amendments, so again, I'm talking very broadly, is that if ever the PSIC says no, there's no ground, the individual could go, bypass that decision, and go directly to the tribunal. And the case would have to be heard. And as Mr. Fergus said, the grounds or the legal threshold that the person would have to go is higher. There are other amendments that are being proposed as well, where the PSIC would not even be involved, depending. So that is also being considered. So in terms of the mechanics, we believe that from the TBS perspective, that this is actually lessening the role of the PSIC in terms of really determining whether there or not there is reprisal, and that naturally, given that we're going to the tribunal, there's potentially a higher cost that will be associated because it's a much more labor-intensive approach with higher standard that needs to be attained in order to prove. And so there would be potentially additional costs and time that would be taken for these cases to be heard. So I'll turn to Marianne to correct if I said anything wrong, but to add.
Thank you very much. So just to be absolutely clear, perhaps everyone already understands this, but just to be absolutely clear, Clause 19 in the bill is the one that provides that where the PSIC has dismissed a complaint of reprisal, the individual can take the complaint themselves to the tribunal. All of the other sections listed by Mr. Fergus are consequential to that amendment. So they're all tied together in one package. If you approve Clause 19, it would mean that the complaint of reprisal would still have to go to the commissioner. The commissioner would investigate, would determine whether or not, as my colleague mentioned, whether there were reasonable grounds for believing that a reprisal had taken place, and then would decide whether or not to refer the complaint to the tribunal. However, with this, what the bill is proposing, even if the commissioner dismissed the complaint on any grounds, so it could be that there was no protected disclosure, it could be that he found that there was no reprisal, the complainant could still basically set aside what the commissioner found and go directly to the tribunal with their complaint of reprisal, where, as was mentioned, they would be facing, instead of reasonable grounds for believing that a reprisal had taken place, at the tribunal they would face the standard of a balance of probabilities. It may not mean a lot to you or I, but in the legal world it's a higher standard than what the commissioner applies. The commissioner, if you've had a chance to read his submission to your committee, has also said that it would basically be setting aside his role, and therefore his investigation, everything done by his office on that complaint, would be wasted.
Can I just add and confirm that if, in the case where the commissioner dismisses that there's no reprisal, the individual can refer that to the federal court for judicial review. So it's not like it's the last step and there's nothing to be done. There's already within the Act a mechanism to have a judicial review of that decision.
Mr. Kuzmierczuk?
That was my exact question, whether there exists an avenue to redress for someone who wants to appeal the decision of PSIC, and it does appear that that avenue already mechanism does exist to get a judicial review. So thank you very much for that clarification.
Ms. Cusi?
Yes, I would also like to ask the experts, if someone failed at PSIC with a lower threshold, why would they go to the tribunal, which has a higher standard?
I'm sorry, I didn't hear the beginning of your...
Sure. If someone failed at PSIC with a lower threshold, why would they go to the tribunal, which has a higher standard?
They
They may not know that there is a higher standard.
Okay.
That's the thing. Like, this is an avenue that the Act would provide to them, which could render cost for them and like a new trial for them. So
But
it's unclear why would
Okay.
they, but that
Yeah.
doesn't mean that they won't.
okay, but if it's a higher standard, then they would fail regardless. Anyway, that's
Most likely. Most
Okay.
likely, yes.
All right. Yeah. Thank you.
Ms. McNola?
Très rapidement,
Yes, very quickly. We were aware that there were some clauses that needed to be amended to not require for royal assent, and each clause, each amendment that we've brought were either very, very carefully reviewed by the legal clerk. And so now you're telling us, well, if they decide to go to the tribunal, it's more costly, and so the royal recommendation is required, but the legal clerk never raised this issue. And this question was asked several times. And to tell people we're taking away the possibility of going before the tribunal for your rights, I don't think it's up to the legislative branch to say that this right will be taken away. The legal right to go before the tribunal will be taken away because that is essentially what is being proposed, is to say we're going to take away the right of the person to go before the tribunal. If you withdraw 14, well, now we're at 15, but if you withdraw these clauses, it's as if you told the person, well, if you want to go before the tribunal, you cannot. This goes against the legal rights of a person and their will, if this is their will. I don't really understand how we can allow for this.
We'll go to Ms. LaRoche, then Mr. Johns.
Merci pour votre...
Thank you for your comment. I have two things to say. I can't really comment on the decision made by the legal clerk. This is not our responsibility. But as analysts and as officials, we can see that there would be potential issues. As for taking away people's rights, in my opinion, this is not the case. Because right now, if the commissioner says no, the person can go before the federal court to have a legal review. 100,000 a case. Well, a legal review, normally, it's a review that happens in writing. So to go before the tribunal could also lead to potential costs for the person. So that's just a comment.
Mr. Johns?
Well, I also have a comment. You know, this should have been brought forward as an amendment before, like everybody else and every other party. We put forward our amendments in advance. Mr. Fergus, to be fair, I mean, a government briefing and page 2 raising concerns about the bill doesn't equate to putting forward amendments ahead of time. You know, we were given notice when we had to provide amendments, and to have this be dropped on us today, I don't think that it's good faith.
Mr. Fergus?
Out of good faith, we shared the note with members last week, early last week, and secondly, you don't need to bring forward amendments if you're seeking to negate a clause.
Are we ready to vote, colleagues? Okay, shall clause 15 carry? No clerk.
Clause 15, Mr. Baines.
No.
Mr. Fergus.
No.
Mr. Juari.
No.
Mr. Kazmierczyk.
Contra.
Ms. Thompson. No. Ms. Block.
Yes.
Mr. Shipley.
Yes.
Ms. Kuzi.
Yes.
Madame Vignola. Oui. Mr. Johns?
Yes.
5 yeas, 5 nays.
I'll vote yes.
Mr. Chair. 6 yeas, 5 nays.
Okay, Clause 16, colleagues.
People will see the light.
You ready to vote, colleagues? Shall Clause 16 carry? Go to a vote.
Mr. Baines?
No.
Mr. Fergus?
Nope.
Mr. Jawari?
No.
Mr. Kazmierczak?
No.
Ms. Thompson?
No.
Ms. Block?
Yes.
Mr. Shipley?
Yes.
Ms. Kuzi?
Yes.
Madame Vignola?
Oui.
Mr. Johns?
Yes.
5 yeas, 5 nays.
Yes again.
6 yeas, 5 nays.
Colleagues, Clause 17, this is, we have an amendment, NDP Amendment 10, which is page 28 of the package.
Mr. Chair, if I could, I'm going to withdraw DP 10, if I could, the will of the committee.
Okay. Well, you don't even have to withdraw it if you haven't moved it, so we'll just skip right over that. So go straight to Clause 17. Shall it carry? Mr. Fergus.
I'd like to thank my colleague for withdrawing NDP 10. For the clause overall, I still think, Mr. Chair, that this is not clear how this is useful. And I would like to ask Madame Vignola, si Madame Vignola peut nous donner...
If Mrs. Vignola could justify how this is useful. When we take into consideration the public interest should always be considered. Especially in a situation where we presume that there is cooperation by the officials to help the whistleblower. So I believe the Commissioner will take this into consideration when it is determined if, yes or no, it should be referred to a tribunal. So it's taking away the obligation of public interest, and also to consider if upper management has taken into account all of these issues. I would like to ask a question of our witnesses, our experts here, in order to help us with this clause in the bill.
So the section of the bill would remove two criteria that the PSIC is supposed to consider before referring to the tribunal, one being the public interest, the other being whether or not either the chief executive or public servants have cooperated in the investigation. I would draw your attention to the submission from the Public Sector Integrity Commissioner, who has said that if you remove the provision which says that he can consider whether or not a chief executive or public servants have cooperated, it would allow departments to simply postpone, and he would never be able to get the complaint to the tribunal, which we think is an important factor to consider. Thank you.
Did you have something, Ms. Vignola?
Si vous pouvez me donner
If you could give me a moment, please.
Go ahead.
L'article a été mis en place
As with all the other clauses, it was implemented by thinking or keeping in mind the public servant. And it's not because an entity is cooperating in an investigation that they're exempt from blame. We see this if someone is cooperating, but in the end, they have to accept fault. I know that the objective is to protect the machine, is to protect the government, but if you leave it there, we make sure that we're protecting the civil servant, the public servant, and this is the most important. When we're protecting the whistleblowing public servant, it's the entire machine that we're protecting because we're showing what are the issues that are being experienced within the machine, and we're trying to improve. We find issues and then we improve. And this is the goal. And I don't see any government, regardless of its stripe, being against this. Because if you find a problem and you solve the problem, this is to the advantage of the government and, in the end, of taxpayers. Quite simply. So this idea of eliminating this part that I take to heart, which is the protection of the public servant, I'm against. And so we can go to a vote if you want, but I cannot provide any clearer argument than that.
Colleagues, can we go to a vote? Shall Clause 17 carry? So we'll go to a recorded vote.
Mr. Baines.
No.
Mr. Fergus. Mr. Jawari.
No.
Mr. Kuzmirchik.
No.
Ms. Thompson.
No.
Ms. Block.
Yes.
Mr. Shipley.
Yes.
Ms. Kuzi.
Yes.
Madame Vignola.
Oui.
Mr. Jones.
Yes.
5 yeas, 5 nays.
Yes again.
6 yeas, 5 nays.
Clause 17 carries. Shall Clause 18 carry? Mr. Fergus.
Again, I will try to make this last argument before we get to the consequential clause, but I really do think that we are complexifying a situation which will not end up being, in the short term, certainly wouldn't be helpful to the complainant, and in the long term, it won't be helpful to either the complainant nor to the purposes of this bill.
We move to a vote, colleagues. Okay. Shall Clause 18 carry? Recorded vote.
Thank you. Mr. Baines.
No.
Mr. Fergus.
No.
Mr. Jawari.
No.
Mr. Kuzmirchik.
No.
Ms. Thompson.
No.
Ms. Block.
Yes.
Mr. Shipley.
Yes.
Ms. Kuzi.
Yes.
Madame Vignola.
Oui.
Mr. Johns.
Yes.
5 yeas, 5 nays.
Yes again.
Thank you, sir. 6 yeas, 5 nays.
Goodbye, Mr. Shipley. Clause 18 carries. Clause 19, we have NDP 11 amendment. Mr. Johns?
Yeah, I'd like to move this. It doesn't require any additional funds. It allows the whistleblowers direct access to the tribunal without any prior determination by the commissioner. And before approaching the tribunal, the whistleblower is required to wait for an indefinite period until the commissioner investigates the complaint of a reprisal and renders a decision while continuing to suffer reprisals. So with this amendment, the whistleblower could immediately approach the tribunal upon experiencing reprisals. This would reduce the delay before justice is done and reduce the harm done in the meantime.
Thanks, Mr. Johns. Sorry, Ms. Vignola, is there a translation issue?
Il n'y avait pas d'interprétation. Le son n'était pas suffisamment bon.
I'm not getting translation now.
There was no translation because the quality of the sound was there was no interpretation during Mr. John's speech because the sound was insufficient.
I guess you were breaking up. Could you please repeat that? Maybe just a tiny bit slower.
I will do that. I hope that this helps. I maybe had the mic too low. Basically, NDP 11, there's no additional funds that are required. It allows whistleblowers direct access to the tribunal without any prior determination by the commissioner. And before approaching the tribunal, the whistleblower is required to wait for an indefinite period until the commissioner investigates the complaint of reprisal and renders a decision while continuing to suffer reprisals. So with this amendment, the whistleblower could immediately approach the tribunal upon experiencing reprisals, and this would reduce the delay before justice is done and reduce the harm done in the meantime. And I just wanted to point out that throughout the expert testimony, this is a best practice, and it has not resulted in sudden jumps in the number of cases in any jurisdictions where it's been adopted.
Thanks, Mr. Johns. Mr. Fergus?
I think for the exact same reasons that Mr. Johns had pointed out are reasons why I would not recommend the passage of this. This is really the key clause, the key article here. What this will do, I mean, Mr. Johns made it very clear, they're not going to even wait for the PSIC determination, which has a lower standard, which is more accessible to the complainant, and will go straight to the tribunal, which has a higher standard, and it requires not only for higher cost to the complainant, but for those who are being accused of doing the wrongdoing, would benefit from support to defend themselves, which of course would mean higher costs, carry higher costs. Anyhow, that's my view on this. I would love to ask again our officials if they could please comment on the implications of carrying clause 19.
Merci beaucoup pour la question, mais en fait,
Thank you for the question, but as mentioned earlier, it is really the clause that links all the other ones together. And so essentially the impact is that it changes the role of the commissioner in the sense that individuals won't have to go through that process. They can go directly. So the role, when there are reprisals, will be lesser. And the commissioner will not be able to rule. So this is the consideration. In addition to the considerations mentioned by Mr. Fergus with regards to the legal test, that is higher for the tribunal than for the commissioner.
Mr. Johns, is your hand still up, or do you wish to address this? Then we'll go Mr. Johns and Mr. Kuzmierczuk.
Maybe if the experts could give us some feedback that, would this amendment not make the tribunal more accessible to the complainant?
yes, thank you for the question. It would make it more accessible because they wouldn't have to wait they would have direct access, and then it wouldn't be stated, like the decision would not be from the commissioner anymore. But what it does is that then the commissioner has no role, and so fundamentally you're changing the role of the commissioner in terms of assessing those reprisals because the person can go directly. And again, as stated, the threshold or the legal threshold is different from one to the other. It is lower based on reasonable ground in terms of the commissioner when he actually looks at the cases. And when it goes to the tribunal, it's more, as Marianne had said, balance of probabilities. But maybe I'll turn to Marianne if you want to add anything.
Thank you. This represents a fundamental change to the structure of the legislation, which in itself, I leave it to you to decide if that's a good thing or a bad thing. But the rest of the law hasn't been designed around this approach. So the way the tribunal has been designed and the way it's been set up is for receiving complaints that have been through the commissioner. So the commissioner has served as the
Triage.
As the triage for complaints to go to the tribunal. This would mean that there would be absolutely no filters before someone goes to the tribunal, which is equivalent to a court. It's a highly judicialized process. So they also would not have the support of the PSIC because he wouldn't be there explaining how he found that there was reprisal and why he's come to the tribunal. They would be left on their own. So I just consider that if this change is going to be made, there may be other changes that would be required in the legislation in order to make this work properly.
Mr. Kuzmichuk?
Thank you, Mr. Chair. As I understand it, the cases that make it through PSIC to the tribunal, these are serious cases that have that there is evidence and grounds to proceed to the tribunal, and obviously one can reasonably conclude that without sort of the filtering screening process of PSIC, you're going to increase the workload of the tribunal. Do you think that this potentially could have, what's the likelihood that this move, by removing the PSIC screening process, would actually delay justice for people, for public servants, for example, who have serious cases, that there's serious grounds to proceed to tribunal? Could this delay their ability to get justice because, again, the tribunal is overloaded with cases, flooded with cases, as you've indicated, is a likelihood?
Thank you for the question. If the tribunal has the same amount of resources and there are more cases, I would assume that it would take a bit more time to filter them and to go through them.
Short answer, justice would be delayed.
Potentially, yes.
Ms. Vignola?
Just get that on.
Merci.
Thank you. First of all, I'm still wondering, who are we to decide in the place of the whistleblower what is the best thing to do? If they have enough with reprisals and with experiencing horrible things to the extent where they say, that's enough, that is enough, I am going to the tribunal, who are we to say you don't have the right to do that? First thing I think about, and secondly, I hear my colleagues say they're going to have so many cases, so many people will do this, that it's going to become a problem. It's going to block up the tribunal. Are things so chaotic in our civil servants? Is the situation dire to this extent? Well, if it is, maybe we should have a more serious bill, because this is what I'm hearing. Oh, the tribunals will be full. That means that there are people that are being quiet, and the act would protect them enough so that would be finally able to lodge a complaint and ensure that the machine will work better. This is what I'm hearing with these fears that are being raised. So I think that we can agree that we're going to disagree and we can go to a vote.
Mr. Fergus?
I'd like to respond to my colleague's concern that things are so dysfunctional within the government and the civil service. That is not the case. And what we're saying, what we are doing here with this proposal is that we're not going to make the situation easier for whistleblowers. What we're going to do two things. First of all, we're going to raise the threshold, the test, the legal test. And this is going to raise the complexity level. If people are facing reprisals, we don't want to make their life more complicated. We want to find solution as quickly as possible with a test that is less high. And that is why we have the commissioner. We all agree that we need to make sure that the commissioner will be able to do his or her job, that we will provide support, and this is why we agreed with many proposals within this bill, Mr. Chair, that allowed to identify not only a person to whom we could make a complaint, but other people as well. We had reduced the threshold. Instead of saying has probable reasonable grounds, or on the basis of, I forget the wording here.
Rather placing in good faith, is that a reasonable understanding. Somebody can make the reasonable case that could bring forth. So we brought that threshold down. We want to see changes, but what we're doing now is that we are opening the door to more cases going to a higher threshold that will take longer to resolve, and I don't think that's helping out the whistleblower.
Colleagues, can we move to a vote? Shall NDP 10 carry? I assume a recorded vote.
NDP 11.
I apologize, NDP 11. Yeah.
NDP 11.
NDP 11.
Mr. Baines.
No.
Mr. Fergus. Mr. Juari.
No.
Mr. Kuzmierczak.
Nope.
Ms. Thompson. No. Mr. Barrett.
Yes.
Ms. Block.
Yes.
Ms. Kuzi.
In favor.
Madame Vignola.
Oui.
Mr. Johns.
Yes.
5 yeas, 5 nays. 6 yeas, 5 nays.
Okay. On to clause 19. Shall clause 19 carry? Oh, I apologize. Shall clause 19 carry as amended? Mr. Barrett, or sorry, Mr. Fergus?
I would say no, Mr. Speaker, Chair.
Mr. Chair, I have NDP 12. Oh, that's 21, sorry.
Yeah. Would you put your hand down, sir? Sorry, Mr. Fergus, did you wish to speak on that?
Est-ce qu'on peut avoir un vote nominal là-dessus?
Could we have a recorded vote, please?
A recorded vote?
On clause 19 is amended, Mr. Baines.
No.
Mr. Fergus.
No.
Mr. Juari. No. Mr. Kuzmierczak.
No.
Ms. Thompson. No. Mr. Barrett.
Yes.
Ms. Block.
Yes.
Ms. Kuzi.
Yes.
Madame Vignola.
Oui.
Mr. Johns.
Yes.
5 yeas, 5 nays.
Yes.
6 yeas, 5 nays.
Clause 19 carries. On to clause 20. Shall clause 20 carry? Mr. Fergus.
So once again, I do believe that we should be voting to negate this article, this clause. I'm sorry, I'm thinking French English, precisely because again, PSIC the commissioner uses a lower threshold, that is reasonable grounds. The tribunal uses a higher threshold of balance of probabilities, and that is going to, again, I'm not certain why we would want to refer people in a vulnerable situation to a higher legal standard than what should be available to them by having a lower legal standard. So that's the reason why I would vote to negate this clause.
Colleagues, can we move to a vote? Shall clause 20 carry? Recorded vote?
Okay.
On division, colleagues, or would you like a recorded vote? You shall have a recorded vote.
Okay.
We're going to come back to this in 5 years.
I can do that. On clause 20. Just make sure Mr. Campbell's got something.
No, but we want to be on the right side. No.
Sorry, can I just interrupt? Just be cordial. Mr. Turnbull, we don't have you subbed in yet to vote. I'll delay for a few moments till we get the paperwork set. Can we?
I can save this one for last if you
Okay.
want.
We'll go ahead with the vote and we'll get back to Mr. Turnbull, okay?
Okay. We'll start with Mr. Fergus on clause 20.
Je vote no.
Merci beaucoup, Mr. Fergus. Mr. Jawari.
No.
Mr. Kuzmirchek.
No.
Ms. Thompson. Mr. Turnbull.
No.
Mr. Barrett. Ms. Block.
Yes.
Ms. Kuzi.
In favor.
Madame Vignola.
Oui.
Mr. Johns.
Yes.
5 yeas, 5
Excuse me,
nays.
the clerk, I'm not, I didn't vote.
Ms. Thompson, I am so sorry. Ms. Thompson.
No.
Thank you so much. I do apologize.
I think we were going to make that assumption for you on your behalf.
Do so.
Yes.
Thank you, sir.
Clause 20 carries. Clause 21, Mr. Johns, now is your opportunity. NDP 12, which is page 30 of the package.
Thank you, Mr. Chair. So NDP 12 requires no additional funds. It extends the reverse onus of proof to all applicants to the tribunal. Whistleblowers who apply to the tribunal currently do not have the benefit of reverse onus and therefore have almost zero chance of success. Every expert this committee asked listed reverse onus as one of the very top amendments we need to make to this bill. Reverse onus is absolutely critical to any hope a whistleblower has to successfully prove reprisal.
Thanks, Mr. Johns. Anyone else wish to address this amendment? Mr. Fergus?
The least I could say is that it does. It's consistent with NDP 11, which was passed here on division. But I would argue the reverse onus part of it is not the part that I disagree. But I do think, and I'm being quite frank here, I do think the existing provisions of the clause is better than what the amendment being proposed on NDP 12. So I'm going to vote against it to allow for the the existing amendments to stand as is.
Anyone else wish to address it? Ms. Vignola?
Pour la greffière législative,
For the law clerk, could you confirm that that this does not incur extra expenses? Thank you for the question. We have checked, or we have reviewed the amendments that are part of the package. This was not raised on behalf of our team. Thank you.
So set close.
Thanks, Mr. Fergus. Shall NDP 12 carry? Recorded vote, colleagues? I will assume going forward we'll do a recorded vote on all of them. Madam Clerk.
yes, sir. On NDP 12, Mr. Fergus.
Vote contre?
Merci. Mr. Turnbull.
No.
Mr. Juari.
No.
Mr. Kuzmierczak. No. Ms. Thompson.
No.
Mr. Barrett.
Nay.
Ms. Block.
Nay.
I'm sorry, that was nay, correct?
Nay.
Nay, thank you. Ms. Kuzi.
Against.
Madame Vignola.
Oui.
Mr. Johns.
Yes.
7 nays, 3 yeas.
Okay, NDP 12 obviously is not passed. Go on to vote for Clause 21. We ready to vote on that, colleagues? Shall Clause 21 carry?
Clause turn 21. Mr. Fergus.
To show that we do support parts of the bill. We vote yes.
Mr. Turnbull.
Oui.
Mr. Juari.
Yes.
Mr. Kuzmierczak.
Yes.
Ms. Thompson.
Yes.
Mr. Barrett.
Yay.
Ms. Block.
Yay.
Ms. Kuzi.
Yay.
Madame Vignola. Mr. Johns.
Nay.
I'm sorry, sir?
Yay.
10 yeas.
Clause 21 carries. We're on to Clause 22. It's Amendment G9, which is page 31 of the package. I'm going to take a wild guess here, then go to maybe Mr. Fergus.
This amendment, this will require tribunal to add reprisers if they are affected by its determination. So I think this is a good change.
Go ahead, Ms. Vignola.
Merci. J'aimerais juste.
Thank you. I'm trying to understand. My interpretation is that it's not really the victim that will determine if they're going to face the aggressor at the tribunal. I believe it should be up to the victim to decide if they will be face-to-face with this person or not. So I'm trying to obtain more detail. Let's ask a question to our witnesses here, our expert resources, to determine how
Affected by the decision of the tribunal.
Thank you. The clause in the bill would automatically add the repriser as a party before the tribunal, so they would always be present. What the amendment in G9 is doing is saying that they would only be present at the tribunal if the tribunal thought they would be affected, usually through discipline, by the outcome of the tribunal, so that if the repriser would not be affected by the outcome, they would not be a party before the tribunal. Is that clearer?
So, excusez-moi, Monsieur le Président.
Sorry, once again. So this means that C290 is suggesting that these people will always be present. And so now what we're saying is that reprisers don't have to be in front of the victims except if there's a consequence on them, on the people who are being accused. So instead of knowing 100% that people will be there, it will be much less time. They will be there for less time. So if I understand this, the person who would be a person who have been reprisers, and if the tribunal determines that they are, and they have to appear before the tribunal, but the victim, the person who has suffered reprisals, cannot say, here is the impact of what you did on me. So perhaps the person who did these reprisals, perhaps there will be no consequences on behalf of the tribunal, but the victim should be able to say to the person, these are the consequences in my life following your actions, and it's not possible to do it if the person who did reprisals is not present at the tribunal. So, once again, we might not agree. So, you just said the opposite of what you said the first time.
Ready to go to the vote? Okay. Shall G9 carry?
Thank you, sir. Mr. Fergus.
Oui.
Mr. Turnbull.
Oui.
Mr. Juari.
Yes.
Mr. Kazmierczak.
Yes.
Ms. Thompson.
Yes.
Mr. Barrett.
Yes.
Ms. Block.
Yes.
Ms. Kuzi.
Yes.
Madame Vignola.
No.
Mr. Johns.
No.
Eight yeas, 2 nays.
Hey, G9 carries. Now, shall clause 22 carry as amended? Mr. Fergus, let Mr. Fergus speak first. Mr. Shorey. Go ahead, Mr. Fergus.
So for the last time, I'm going to make a request that we negate this clause. Again, because we will be making this.
Sorry, if you don't mind me interrupting, it was originally 23 was on your list to negate. We're on 22.
I'm sorry. I thought we 20. Oh, my apologies. My apologies.
Yes, and you said no. I said like.
My sincere apology.
We'll go to the vote. Shall 22 carry as amended? There we go. Around 20.
Do you
So
want to
recorded vote. Go ahead, please.
Okay. Mr. Fergus.
Oui.
Merci. Mr. Juari.
Yes.
Mr. Turnbull.
Oui.
Mr. Kazmierczak.
Yes.
Ms. Thompson.
Yes.
Mr. Barrett.
Yes.
Ms. Block.
Yes.
Ms. Kuzi.
Yes.
Madame Vignola.
No.
Mr. Johns.
No.
8 yeas, 2 nays.
Clause 22 carries. Now, clause 23. Mr. Fergus, would you like to start again?
Well, I won't waste the committee's time. If you can apply what I just said earlier.
Okay.
Roll the tape.
Colleagues, can we go to vote? Shall Clause 23 carry? Recorded.
Okay. Clause 23, Mr. Fergus.
No.
Mr. Turnbull.
No.
Mr. Jawari.
No.
Mr. Kazmierczyk.
No.
Ms. Thompson.
No.
Mr. Barrett.
Yay.
Ms. Bloch.
Yay.
Ms. Kuzi.
Yay.
Madame Vignola.
Oui.
Mr. Johns.
Yes.
5 yeas, 5 nays.
Yes.
6 yeas, 5 nays.
Clause 23 carries. Clause 24. Shall 24 carry, colleagues? Are there any changes to 24 and 25, Mr. Fergus, that we could maybe have UC to combine the two of them?
So on 24, Mr. Chair, I would agree. And 25, I would like to propose to negate. So
Okay.
I'm sorry, we can't.
Oh, that's
I can't
fair.
do that this time.
I thought I would ask. We'll stick with Clause 23, or sorry, Clause 24. Shall Clause 24 carry? We'll go straight to a vote. Madam Clerk?
Clause 24, Mr. Fergus.
So on clause 20, we're on clause 25? Well then, since I'm happy to let it stand, I'm happy to let it stand.
Yes? Yes, sir?
Yes.
Yes, thank you. Mr. Turnbull.
Oui.
Yes. Mr. Jawari.
Yes.
Mr. Kazmierczyk.
Yes.
Ms. Thompson.
Yes.
Thank you. Mr. Barrett.
Yay.
Ms. Bloch.
Yay.
Ms. Kuzi.
Yay.
Madame Vignola.
Oui.
Mr. Johns.
Yes.
Thank you, sir. 10 yeas.
Clause 24. Sorry.
I'm a little confused. I thought because, what was the vote that we took before 24?
23.
So we did G9, which we approved, and then we did.
We did
Did
22.
we have to do the clause?
We did 23.
My apologies.
That's okay.
Then just if I could just let the record know, I misvoted on 23. I would have voted again to negate it. I thought that's the vote that we had.
We did on 24.
And then on 24,
24, we just voted.
Okay, I'm sorry. I must have, for some reason, I think I had an extra vote in there.
Nope, we're good. And we did say, and I understand probably where the confusion was from. It looked like 24, we were just going to probably carry on division, but we stated we were going to go every single one. We're going to do a recorded vote. So 24 is carried, Madam Clerk. We're clause 25 now. Mr. Fergus, did you want to address that?
Yes. I recommend that we overlap this so that we could avoid duplication. So it prevents overlap with the recourse mechanisms for reprisals. And that's the reason why I think that we should be negating this this clause. As I said earlier, what will happen if we don't is that we will have different bodies producing different results with different answers in terms of what will happen if people decide to pursue 2 or 3 different recourse mechanisms. So that's the reason why I would vote against.
Does anyone else wish to address, or can we move to the vote? Okay. Shall 25, Mr. Jory? Oh, we would wait, don't worry. Shall 25 carry? Recorded vote, ma'am?
On clause 25, Mr. Fergus. Mr. Turnbull.
Against.
Mr. Jawari.
Against.
Mr. Kazmierczyk.
Nay.
Ms. Thompson.
No.
Mr. Barrett.
Nay.
Ms. Bloch.
Nay.
Ms. Kuzi.
Against.
Madame Vignola.
Oui.
Mr. Johns.
Yes.
8 nays, 2 yeas.
Sorry, 8 nays? Did you hear that right? Okay. Sorry, 8 nays, so the clause is defeated. Clause 26, we're on G10, which is page 32 of the handout. Mr. Fergus?
Pour rendre ça plus
It's to make it more consistent with the decisions that we had taken beforehand. We want to add to this notion of on the basis of reasonable belief. So once again, this will reduce the threshold. It's to add coherency with the other decisions made beforehand.
Thanks, Mr. Fergus. It looks like we're ready to go to a vote. Shall G10 carry?
Mr. Fergus. Mr. Turnbull.
Oui.
Mr. Jawari.
Oui.
Mr. Kazmirchik.
Yes.
Ms. Thompson.
Yes.
Mr. Barrett.
Yay.
Ms. Block.
Yay.
Ms. Kuzi.
Yay.
Madame Vignola.
Oui.
Mr. Johns.
Yes.
10 yeas.
G10 carries. Thank you, colleagues. We're now on to Amendment Lib 9, which is page 32-1. Oh, Mr.
Thank you,
Chouari,
Mr.
you're
Chair.
going
This is an amendment to clause 26, naturally, that we are suggesting that we add after line 2 on page 7 the following. If the commissioner refuses to deal with the disclosure or commence an investigation, he or she must provide the person who made the disclosure with information on the most appropriate procedures for dealing with the disclosure. Many times we heard that the commissioner did not, or in the past at least, there was no guidance provided as a next step. We think this is a good amendment.
Right. Ms. Vignola?
Question.
I have a quick question. I found that Lib 9 was similar to Lib 8, and I'm wondering, since we passed Lib 8, is now Lib 9 extraneous or not? Is it redundant? It's a question of understanding.
We actually replaced Lib 8 by G7.1. So
Lib 8 was withdrawn.
Yes. It was withdrawn and it was replaced by 7.1.
7.1.
Yep.
C'est ça. Excusez-moi.
Sorry, 7.1. Okay, well, same question.
Wonderful. Recorded vote. Shall Lib 9 carry?
Mr. Fergus. Merci. Mr. Turnbull.
Yes.
Mr. Jawari.
Yes.
Mr. Kazmirchik.
Yes.
Ms. Thompson.
Yes.
Mr. Barrett.
Yes.
Ms. Block.
Yes.
Ms. Kuzi.
Yes.
Madame Vignola.
Oui.
Mr. Johns.
Yes.
10 yeas.
Lib 9 carries, probably because it's from Mr. Jawari. Well done. Shall Clause 26 carry as amended? Ready to go right to a vote?
As amended. Mr. Fergus.
Clause 26 as amended.
Yes. Thank you.
Mr. Turnbull.
Yes.
Mr. Jawari.
Yes.
Mr. Kazmirchik.
Yes.
Ms. Thompson.
Yes.
Mr. Barrett.
Yes.
Ms. Block.
Yes.
Ms. Kuzi.
Yes.
Madame Vignola.
Oui.
Mr. Johns.
Yes.
10 yeas.
Clause 26 is carried as amended. Shall Clause 27 carry? Mr. Fergus, you wish to address it?
So once again, consistent with clause 25, we want to just make sure there is not overlap and duplication and wasting resources by having multiple avenues which are available. And so this is a reason why we would recommend to negate this clause.
To address that, Ms. Vignola?
Donc, l'article de...
So this removes one aspect of the original act, and I don't see. Well, we've already allowed the civil servants to have the power to use other resources, so it takes out the paragraph J that says other authorities according to Section 34, so we leave it up to the civil servants to decide where the complaint will be made, to whom they will tell, and who will be asked to protect them. So I would keep it. I would keep what's there.
Madame Laroche or Ms. Stevens to comment on this particular clause.
Thank you. Clause 27 is basically consequential to Clause 30 of the bill, even though it comes before Clause 30, because it's a reference to Section 34 in the PSDPA, which Clause 30 removes. So this amendment in 25 sub 1 sub J makes a reference to Clause 34. So I presume that's why the bill is removing that subclause.
Ms. LaRoche, did you have something? Was there anything else, Ms. Stevens?
Should I explain Section 34?
I'm not asking or directing you one way or the other. You just looked like you wanted to speak on Clause 27 further.
The implication would be that if Clause 30 were to be defeated, you would have wanted to keep this subclause that's referred to in Clause 27 of the bill, because Section 34 of the PSDPA is a provision which prevents the commissioner from going outside the public sector. And there are concerns that if Section 34 is removed from the PSDPA, it would open not just the private sector, but also the excluded organizations to investigations by the PSIC.
Move to a vote, colleagues. Shall Clause 27 carry? Court of Division.
Clause 27, Mr. Fergus.
No.
Mr. Turnbull.
No.
Mr. Jawari.
No.
Mr. Kuzmirchik.
No.
Ms. Thompson. No. Mr. Barrett.
Yay.
Ms. Block.
Yay.
Ms. Kuzi.
Yay.
Madame Vignola.
Oui.
Mr. Johns.
Yes.
5 yeas, 5 nays. 6 yeas, 5 nays.
Clause 27 carries. Mr. Barrett?
On NDP 12, the votes recorded me as having said yay, but my intention and my voice said nay. So I'm looking for UC to have it recorded as nay.
Excuse me 2 seconds. Colleagues, Does Mr. Barrett have UC?
no,
It does not change
no,
the
No.
vote. Okay. Your amendment is defeated, Mr. Barrett. Clause 28. Shall Clause 28 carry? Colleagues, can we go to a vote, or Mr. Barrett? Or sorry, Mr. Fergus, sorry.
So again, I'd like to thank my colleague, Mr. Johns, for proposing this. Frankly, the implications of this is that the Information Commissioner will be setting policy piecemeal throughout the government. We think it's better for the Treasury Board Secretariat to set a standard. Oh, I'm sorry. Did I misunderstand NDP 13?
Yeah, Mr. Fergus, sorry, we're on 28. Sorry to interrupt you. We're not. Oh, I apologize.
That's good.
We're going to go to. Yeah, so we're at 28, and then we have to go to 28.1.
So we're
So
on
we're on 28 first.
NDP 13 is on 28.1. That's okay.
So we're on 28, and then we'll get to you, Mr. Johns, for 28.1. Did you wish to address anything on 28?
If I remember correctly, is this one about the legal aid?
Colleagues, I'm just going to suspend for a couple minutes. I'm going to let you work out that, and then I have something to address. Just for 2 minutes. back in. Are we ready to vote on Clause 28? Shall Clause 28 carry? The recorded vote?
Thank you, sir. Clause 28, Mr. Fergus. Thank you, sir. I'll take that in the affirmative. Mr. Turnbull.
That's a yes. Just give us the thumbs up, Ryan.
Yes.
I don't believe
Yes.
No.
Mr. Jawari.
Yes.
Thank you, sir. Mr. Kuzmirchuk.
Yes.
Ms. Dobson. Yes. Thank you. Mr. Barrett.
Yes.
Thank you, sir. Ms. Block.
Yes.
Ms. Kuzi.
Yes.
Madame Vignola.
Oui.
Merci. Mr. Johns.
Yay.
Thank you, sir. 10 yeas.
New Clause 28.1, and we have Amendment NDP 13, which is page 33 of the package. Mr. Johns?
Yes.
see your hand
So there's no additional funds required. It defines standards for investigations, addressing training and qualifications of investigators and independence of investigative operations in line with best practices. So there is considerable evidence of superficial, incompetent, biased, and even malign investigations by PSIC. It is their standard practice to completely exclude whistleblowers from the process, keeping them uninformed or misinformed about progress, failing to interview them or process their information that they have, failing to interview other key witnesses they suggest, and denying them sight of the final report so that they are unable to rebut false information. And in one case investigated by FAIR, PSIC effectively sabotaged an important investigation that was making good progress by quietly allowing the investigator's contract to lapse and then closing the case abruptly without following the lines of inquiry already established. So with this amendment, investigations would be conducted competently and independently, thus ensuring proper due process for all parties. Without opportunities to pressure bias investigations, wrongdoers would be more reliably exposed and the public interest would be better protected. So wrongdoers would be denied the opportunity to expand their powers and conduct more serious wrongdoing, examples like Phoenix and Limigantic. So the investigation in P6 primary mandate, the words investigate or investigation appear more than 100 times in the PSDPA. So this is a responsibility that should already be budgeted for.
Thanks, Mr. Johns. Mr. Fergus?
I believe that what we should do is allow, for the purposes of setting standards for internal investigations, we should allow TBS to play that role. That's the role that the Treasury Board Secretariat does play in terms of establishing government-wide standards. And it would be one that would apply for, throughout the entire government organization, as opposed to what is being proposed here for the Public Service and Commissioner to be able to determine what the standards are.
Want to address that, Mr. Johns, or are we ready to vote?
Let's vote.
NDP 13 carry.
Okay. Yes, sir.
Yes, sorry, we're going to do...
Yeah, let's have a recorded division on that.
Mr. Fergus.
No.
No. Thank you, sir. Mr. Turnbull.
No.
Thank you, sir. Mr. Jawari.
No.
Mr. Kazmierczyk?
Nope.
Ms. Thompson?
No.
Mr. Barrett?
No.
Ms. Block?
No.
Ms. Kuzi?
Hard pass.
Madame Vignola?
Oui.
Merci. Mr. Johns?
Yes.
8 nays, 2 yeas.
NDP 13 is defeated. Therefore, there is no new clause 28.1. Lib 10 has been withdrawn. So we're now on clause 29. Can we go direct to a vote, colleagues? Mr. Fergus?
So, again, I'm just going to just make sure that we're consistent here. So, consistent with clause 25, I believe that for clause 29 that this is a consequential aspect. So I would suggest that to be consistent with our vote, we should vote to negate this, as we did on clause 25.
Colleagues? Right. Shall clause 29 carry? It was withdrawn.
Sorry, I missed that part. My apologies when I was over there chatting.
Sorry. Go ahead.
Yeah, we're good on 29. Yeah.
We're voting on 29.
Mr. Fergus?
No.
Mr. Turnbull?
No.
Mr. Johari?
No.
Mr. Kazmierczyk?
No.
Ms. Thompson?
No.
Mr. Barrett?
Yay.
Ms. Block?
Yes.
Ms. Kuzi?
Yes.
Madame Vignola?
Oui.
Mr. Johns?
Yes.
10, oh, sorry, 2, 3, 4, 5. 5 nays, 5 yeas.
I'll vote yes.
Sir, 6 yeas, 5 nays.
Clause 29 carries. We're on to clause 30, and it's amendment G 10.01, which is 33.2 of the package. I'll give Mr. Fergus a moment to come back for this. And for a couple moments.
Again, this one is just making sure that that the law would apply, except for when it comes to Canadian Armed Forces, the Canadian Security Establishment, as well as the Canadian Security and Intelligence Service, where these kind of investigations will be referred to NSIRA, the National Security and Intelligence Review Agency.
A moment.
Did you have anything, Ms. Vignola?
I don't understand what Army, Canadian Forces, CSIS. I don't understand. There's a series. There's. I don't understand the sentence here. So what I'm saying is that because these investigations would probably obtain information from CSIS, for example. So in the cases of the Canadian Forces, this is G 10.01? Yes, G 10.01. Amendment 10.01. That's right? Okay, thank you.
Context.
Merci.
C'est correct? C'est beau.
Okay, ready to vote, colleagues? Shall G10.01 carry? Please.
Thank you, sir. Mr. Fergus.
Oui.
Mr. Turnbull.
Yes.
Mr. Jawari.
Yes.
Mr. Kazmierczak.
Yes.
Ms. Thompson.
Yes.
Mr. Barrett.
Yay.
Ms. Block.
Yes.
Ms. Kuzi.
Yes.
Madame Vignola.
Oui.
Mr. Johns.
Yes.
10 yeas.
10.01 carries. So shall clause 30 carry as amended? Ready to go straight to a vote, colleagues? Thank you.
30 as amended. Mr. Fergus.
Oui.
Mr. Turnbull.
Yes.
Mr. Jawari.
Yes.
Mr. Kazmierczak.
Yes.
Ms. Thompson.
Yes.
Mr. Barrett.
Yes.
Ms. Block.
Yes.
Ms. Kuzi.
Yes.
Madame Vignola.
Oui.
Mr. Johns.
Wait.
10 yeas.
Clause 30 carries. Shall clause 31 carry? Which is not 31.1, which is NDP 14. So,
Well, no.
Mr. Fergus?
I'm sorry. So when you say clause 31 as is,
NDP 14 would create a new clause 31.1.
so do you want to do NDP 14 and then ask if 31 as amended?
Nope. Just 31. Yeah. The NEP, if it passes, will create its own clause. So 31 will be standalone. Did you wish to address it, Mr. Fergus, or?
I'm not in favor of clause 31 as
We
a
will
standalone.
go to a vote. Madam Clerk? Shall
31?
31 carry, yes.
Mr. Fergus. Mr. Fergus?
Yes.
Thank you, sir.
Earlier.
Mr. Turnbull.
En faveur?
Mr. Jawari.
Yes.
Mr. Kazmierczak.
Yes.
Ms. Thompson.
Yes.
Mr. Barrett.
Yay.
Ms. Block.
Yes.
Ms. Kuzi.
Yay.
Madame Vignola.
Oui.
Mr. Johns.
Yes.
10 yeas.
Oh, clause 31 carries. We're now on to NDP 14, which, if it does pass, will create a new clause 31.1. So, Mr. Johns, NDP 14, which
Thank
is
you,
page
Mr.
30.
Chair.
You're following along at home.
Yeah, so this extends the current provisions for interim relief to all parties. Interim relief or injunctive release was the top priority for every expert we heard from when asked about what amendments are most critically needed. The whistleblower must absolutely be protected as soon as they make disclosures, instead of waiting for reprisals to happen and spending time and resources trying to address them. After the fact, reprisals should be prevented as soon as a disclosure is made. Currently, interim relief can be provided to those accused of reprisals, but not to the whistleblower. Sections 19.5 and 19.6 demonstrate a central theme of the PSDPA and protection of those accused and disregard of the whistleblower's fate. It's absolutely absurd. So this amendment, interim relief would be automatically provided to all parties. This would ensure that due process is completed before any disciplinary or detrimental actions can be taken against any of the parties.
Thank you, Mr. Johns. Mr. Fergus, and then Ms. Vignola.
So I'm a little confused as to the explanation offered by Mr. Johns, but and Mr. Johns, I'd love to hear from him again, but I'm wondering if our officials can give us a bit of a sense as to what would be the import of passing NDP 14.
Merci pour la question. En fait,
Thank you for the question. The proposal of NDP 14, it's a definition of reprisal that could be made against the whistleblower or others, but this definition is already in the Act in the definition section. We would consider this addition as being redundant, given it's already defined in the Act.
I would just say that Mr. Johns has spoken of injunctive relief, but I don't see that in NDP 14. So I'm sorry, I'm confused. I'm not sure how to clarify this.
Okay, Mr. Johns, I've got Ms. Vignola, then I'll come back to you for that.
NDP 14.
NDP 14, I'm reading and rereading it, and it's not a list of reprisals. It says that if the commissioner finds that a wrongdoing has been committed, none of the following measures shall be taken against a public servant who made the disclosure of wrongdoing. So all of this during the investigation. So it protects the civil servant from the beginning, during the investigation. But I'm looking at NDP 14. The Act is amended by adding the following after Section 35. If during the course of an investigation, the Commissioner finds that a wrongdoing has been committed, none of the following measures shall be taken against the public servant who made the disclosure of wrongdoing. And there are 5 things that cannot be done to a public servant who has already suffered reprisals. So this is not a new list. It's not a reminder. We're saying during an investigation, we're protecting the public servant.
Mr. Johns? And then, I'm sorry, Mr. Fergus?
Well, I very much appreciate what Ms. Vignola just added to it, but also, if it's redundant, then it should be no problem passing it.
Mr. Fergus?
I think our officials love to
Sorry.
comment.
Go ahead, please.
Sorry, I would just say that under the Act, the way it is currently written, the protection starts from when you make the disclosure. You don't need to have an investigation. The protection is from the time when you make the disclosure. So this is after that. So you would already be protected from everything that is listed in this amendment.
Ready to vote, colleagues? Right. Shall NDP 14 carry? Madam Clerk?
NDP 14, Mr. Fergus.
No.
Mr. Turnbull.
No.
Mr. Juari.
No.
Mr. Kazmierczyk.
Nope.
Ms. Thompson.
No.
Mr. Barrett.
No.
Ms. Block.
No.
Ms. Kuzi.
No.
Madame Vignola.
Oui.
Mr. Johns.
Yes.
Thank you, sir. 8 nays, 2 yeas.
Okay, NDP 14 is defeated. We're now on to Clause 32. Are we prepared to go straight to vote, colleagues? Shall Clause 32 carry? Madam Clerk, we'll vote.
32, Mr. Fergus. Mr. Turnbull.
Yes.
Mr. Juari.
Yes.
Mr. Kazmierczyk.
Yes.
Ms. Thompson.
Yes.
Mr. Barrett.
Yay.
Ms. Block.
Yes.
Ms. Kuzi.
Yes.
Madame Vignola.
Oui.
Mr. Johns.
Yes.
Thank you, sir. 10 yeas.
Okay, Clause 32 carries. Now, colleagues, we only have 4 minutes left, so I'm not going to get into NDP 15. I think by the looks of it, we've got about an hour and a bit left to get through. The 14th, we have the PBO here. There's, depending on the length of questioning, we might have an opportunity to get to a short amount of C290 on the 14th. The 19th, we have the departments on the McKinsey docks. And then the 19th is a cutoff that pretty much that we have, or the 20th, to get this back to the House. Once in a while, there are some dates floating out there for a couple hours here or there for meetings. If colleagues are in agreement, leave it with me. I will try to nab the first spot of any available resources so that we can finish this off. If you're in agreement to leave that with me and the clerk, colleagues. Wonderful. If there's nothing else, we'll... Oh, did you have something? No? Okay. If there's nothing else, we will adjourn, and we will see you on the 14th. I understand there are a lot of votes, even though we're starting at 4:30, so hopefully we can get to it on time. We will adjourn. Thanks, colleagues.